Right out of the gate, the judge lays down the stakes, up to a year in jail and a $4,000 fine. But here's the kicker. This case isn't just about a minor fender bender in a McDonald's parking lot. It's about what happens when pride, anger, and impulse collide with the law. Instead of calling the police, the defendant took matters into his own hands, escalating a routine accident into an assault charge. Viewers, ask yourself this. If someone hit your car and drove off, would you chase them down or swallow your pride and dial 911? Because in this courtroom, that split-second decision is the difference between walking free and facing jail time.
And/or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present during questions and interviews with the state of Texas. If you cannot afford a lawyer will be appointed to represent you, sir.
Second, please before deputy arrives at a McDonald's parking lot at 13532 Beechnut Street in Harris County, Texas, where he made contact with the defendant and a complainant who were near their vehicles. The complainant and the defendant do not know each other. The complainant stated that when he was driving on the public roadway, he accidentally backed his vehicle into the defendant's front bumper. The complainant believed that he did not strike the defendant's vehicle at the time of the impact and drove away onto the cross street. The defendant began to follow him. The complainant parked his vehicle in the McDonald's parking lot and observed the defendant's vehicle stop behind his car. The defendant approached the driver's door of the complainant's vehicle. The complainant opened his driver's door and asked the defendant, "Hey bro, are we good?" The defendant became verbally aggressive towards the complainant, yelling at him and telling him that he hit his car. The complainant remained sitting down in his driver's seat. The defendant was so close to the complainant that the complainant could not walk out of the vehicle. The defendant with his left fist struck the complainant on the right side of his face, causing pain. The defendant repeatedly told the complainant to get out of the car. The complainant remained in the vehicle while the defendant continued to yell at him, standing outside of the driver's side of the vehicle. The complainant had a purple discoloration mark with red swelling on his right cheek, consistent with that of a physical assault. The white area of the complainant's right eye was pink compared to his left eye. A vehicle inventory of the defendant's vehicle revealed a clear plastic bag containing two separate plastic bags of marijuana. Total weight 83 grams, 2.9 ounces.
The judge's tone sharpens here. And honestly, can you blame him? He's spelling out a universal truth. Violence never pays in court. Had the defendant simply called the authorities, the law would have worked in his favor. But instead, he's now the aggressor. Here's the moral dilemma for you at home. What matters more in the heat of the moment? Justice or your ego? Because that one punch not only flipped the script, it shifted the sympathy of the entire courtroom. Let me ask you directly. Do you think the defendant's anger was justified or reckless? Comment your verdict below. I want to hear where you stand.
9 ounces.
Mr. Wyckoff, I'm going to find that there's probable cause to go forward with the case. I'm going to tell you that all you really had to do was call the cops when that dude took off, and then they probably would have had that dude arrested. But now, because you took matters into your own hands, you and I are not going to have a good time. I am now sending you for a drug test. I want to know what, if anything, is in your system, and you must come right back to court. Do you understand?
Yes, sir.
Do you have a Texas driver license?
Yes, sir.
You run his license, please. Do you have valid liability insurance in your name?
Yes, sir.
I want proof before you leave here today to see whether I'm going to allow you to drive or not. Number one. Number two, as a condition of your bond, you are not allowed to use dope or any kind of dope whatsoever or alcohol. If I find that you're using anything, I'm going to put you in jail and I'm going to make your bond sky high. Do you understand?
Yes, sir.
This license is eligible, Judge.
Thank you. I'm ordering you also as a condition of your bond not to be in possession of any weapons and not to have any contact with the complaining witness in this case. Rachel, I'd like to send him down right now for a drug test. I'm going to have you sign a receipt and then I'm going to hand you off to take a drug test and then you must come right back. Do you understand?
And here it is, the bombshell. The drug test comes back positive for cocaine. Now pause for a second. This isn't just courtroom drama. This is a credibility collapse. Every excuse, every plea, every protest from the defendant now sits under the shadow of that result. But here's the legal angle. Testing positive doesn't just affect this case. It can slam the door on leniency. Judges see it as defiance, as a refusal to take the process seriously. Think about it. How do you convince a court you're trustworthy when the evidence in your bloodstream says otherwise? This moment changed everything.
Okay. Mr. Wyckoff tested positive for cocaine. He also tested positive for, what else was it? Mr. Wyckoff, I'm going to tell you now, I'm not putting up with it. I'm not going to let you do this while you're on my watch. So it's okay. It stops now. And if you don't, we have one place for it. You understand? You will be drug tested like crazy. I'm going to bring you here 2 times a week so that you prove to me that you're not consuming any kind of cocaine, alcohol, or any dope whatsoever. And the first time you test positive, you will go to jail. I know that you're going to test positive now for the next 3 days, maybe 4, but after that time, if you have continued to test positive for cocaine, then you will go to jail. As far as the weed is concerned, I will give you a 35 to 40-day window. And after that, if you test positive, that tells you that you've continued to use, and likewise, you will go to jail. And I'm going to tell you now, no more PR bonds. Do you understand? I don't care if you're mad at me. I don't care if you're, look.
I'm not gonna make it 2 times a week.
Well, then,
Drug test, no, I work and everything. No, that's not gonna happen.
yes, it is.
All right.
I will give you the opportunity. If you don't, then that's fine. You don't have to come. You know what's going to happen, and that's it.
Judge, I would ask the court to consider just either once a week or every 2 weeks.
No, because he can still use and he can evade capture with it. And, I don't want you to continue to use cocaine, and that's it. And I'm not going to trust you.
I can't even use cocaine. I have asthma. That stuff will break my lungs.
You tested positive for it.
I can't use it.
Well, okay. Prove it.
I have asthma. It's in the system.
Prove it. I'm not going to take your word for it. So that's I've already given you a lawyer, Mr. Wyckoff. You know what's expected of you. All you have to do, I'm not asking you to show up here. I'm asking you to just go take a test, and then you can take
Like I
off.
said, I work. I'm not going to take 2 times out a week to go take a test. No.
That is the bond condition.
All right. I could have paid my own bond for that.
It's still a condition I'm going to put on you, whether you paid your own bond or not. If you don't like it, don't pick up a new case. Easy solution. And I hope that now it becomes so miserable that you think twice before you follow someone next time. Because, like I said, had you probably just called the cops, they would have chased that person and arrested
I
him.
followed them to get their driver's license number. And I didn't follow them.
Don't talk about the case. I don't want to talk about the case. I'm just telling you what's expected of you, sir.
I should've.
Today's Tuesday. So what I'll do is I'm not going to have you come back on Thursday because I know that it's not going to be. So we can start Monday, the testing on Monday, and we'll go from there. You will have to go take a drug test on Monday, submit it to the lab, and then you can go on about your business. If you test positive, you will be brought to court, and then we'll address it at that time. All right. Any questions? Anything else? Okay. Good luck, Mr. Wyckoff. Mr. Wyckoff, I'm going to tell you, if you try to get into a pissing match with me, it's not going to go well with you.
Stop, the judge is talking. Face the judge when he's talking to you.
Bring it.
Step over there. You done with it?
By the end, the judge isn't just laying down the law. He's laying down the psychology. Don't get into a pissing match with me. That's not legal jargon, that's raw authority. The defendant's backtalk has officially worn thin, and the courtroom has turned into a cautionary tale about arrogance colliding with accountability. So here's the big takeaway. This case isn't about a fender bender. It's about how quickly ego can wreck your future in front of a judge. And I'll leave you with this. If this case stunned you like it did me, smash that like button, comment your verdict below, and subscribe for more courtroom breakdowns every single week. Because trust me, this was just one of many jaw-dropping moments happening inside America's courtrooms.